General, I'd like to, just understand kind of the scope of your argument here on the Supremacy Clause and how it operates in your mind, putting aside this case. Could the federal government condition the receipt of funds on hospitals that they comply with medical ethics rules provided for by the federal government, a medical malpractice regime, and a medical licensing regime, such that effectively all state medical malpractice laws, all state medical licensing laws would be preempted?
And you're imagining that this is regulatory action, or that Congress has passed a statute creating kind of a federal malpractice regime?
You call it.
I mean, I think I have a broad view of Congress's authority to enact statutes, and so what I'd want to assess in that situation is, whether Congress is acting pursuant to one of its enumerated powers.
Spending clause. It was all spending clause.
Yeah. So I think that very likely Congress could make those kinds of judgments and attach conditions to the receipt of federal funds. And in Medicare, there are substantial conditions.
All hospitals in the state and effectively transforms the regulation of medicine into a federal function?
There might be a point at which this court thinks that it's really encroaching on the state's prerogatives in ways that are inconsistent with our constitutional structure, but I don't think we're anywhere close to that in this
But do you see any bounds just in principle?
I think the bounds, would have to come from this court's case law concerning federalism principles. The court has said in cases like Gonzalez versus Oregon that, of course, the federal government has authority to comprehensively regulate on health and safety, including with respect to medical care. And so I don't think that there's any principle of exclusive governance of this area by the state. But obviously, I'm sure you could construct hypotheticals that really seem to be the federal government entirely taking over a state function, and maybe that would be subject to a different principle.
Yeah. EMTALA and Medicare allow the federal government to enforce the EMTALA dictate through civil monetary penalties?
That's correct, yes.
And also you can terminate the Medicare agreements if a hospital violates EMTALA, in your view?
Yes. Generally, the hospital is given the opportunity to come into compliance and to develop a plan to ensure that there won't be future EMTALA violations. It would obviously be an extreme sanction to terminate Medicare funding, but that is a possibility.
And there's also a private right of action for EMTALA violations that have the possibility of equitable relief as well.
Yes. Certainly monetary relief and possibly equitable relief as well.
In this case, you brought an equitable cause of action. You didn't cite any statute to enforce EMTALA. And one of the rules in equity, traditionally at least, is that you don't get an equitable relief if there's an adequate remedy at law. And as we just discussed, there's a pretty reticulated statute here. Seminole Tribe says when you have a reticulated statute and lots of remedial options, you don't get equitable relief. Thoughts?
So let me say at the outset that the United States has long been recognized to have an action in equity, an inherent action in equity, to appeal to the courts of this nation to protect its sovereign interests.
It's sovereign.
And that's been reflected in things like
interests. You mentioned Washington and you mentioned
Arizona versus the United States is another example of that.
Arizona was, just sorry to interrupt, but Arizona was an immigration case and border, and Washington was an attempt by a state to impose its worker compensation laws on the federal government in a way different from others. I take those points, and equity is all about proprietary interests and things like that. Do we have that here?
Well, I think that the court, it's not, I want to make sure to make clear that there are a long line of cases that stand for this principle, including cases that have addressed it directly, like In re Debs, Wyandotte.
Do you really want to rely on Debs, General? I mean, that wasn't exactly our brightest moment.
I do think, though, that it reflects the history and tradition of this nation and recognizing that it's entirely appropriate for the United States to seek to protect its interests in this manner. And let me say, Justice Gorsuch, this is a really important issue to the United States. It wasn't pressed below. It wasn't passed upon. We haven't briefed it at all. It's not jurisdictional.
I'm just trying to understand where it comes from. What is the proprietary interest here?
It seems
to me it's your money and how it's being spent, and Congress has given you lots of tools.
I think it also comes from the recognition under obstacle preemption principles that there are important functions to be served by having the Medicare program in place, and Idaho has directly interfered with the ability of hospitals to accept these federal funds when they stand willing and able to comply with EMTALA's mandates and fulfill Congress's desire here to make sure that no matter where you are in this country, if you have an urgent medical need and you go to an ER, you can be stabilized.
Thank you.